Hello everyone, this is Advocate Meghana Dhairyawan and I welcome you all to msdlegal channel. You are watching Know the Law series and today's episode is very special and it has been recorded on auspicious occasion of International Mother's Day, and I wish you all a very International Mother's Day as such. Today's topic is dedicated on this occasion and we are going to discuss special provisions which are in relation to the maternity benefit given to adoptive mother and commissioning mother under surrogacy. Let us start with today's discussion. We all know under Maternity Benefit Act 1961, all working women are given a maternity benefit of 12 weeks which is extended to 26 weeks in amendment of 2002. However, we all should appreciate that the special provisions were also extended extended this benefit to adoptive mothers who are not the natural mothers or biological mothers. However, if any working woman who is adopting a child below 3 months, she is entitled to maternity leave of 12 weeks as such. Also, under surrogacy, the commissioning mother was recognized as a biological mother and she has also been extended the same maternity benefit of 12 weeks. Now let us understand this technicality as to what is commissioning mother. Commissioning mother is the mother who has given her egg for implanting in another woman to create the embryo, and whenever that surrogated mother will deliver a child, that child will come to the commissioning mother and she will start with her motherhood. But we all know this does not involve her own biological process, or she does not physically deliver the child. That is the reason why technically she was not mother as per earlier law, and she was not given that maternity benefit act as such. However, with the amendment in 2002, this benefit was extended to commissioning mother, and she can avail the 12 weeks maternity benefit as such. So these two were the special highlights of Maternity Benefit Act. Apart from this, we must understand in the regular course, the regular mothers, that is the biological mothers, can now extend this maternity leave of 26 leave, which was earlier 12 weeks. So that was also enhanced. The only condition to take these benefits is that woman has to work at least 80 days in preceding 12 months in that particular establishment. If that is the case, then she can definitely avail this benefit under Maternity Benefit Act. So apart from this, there are a lot of other acts which protects the woman's interest as to the illegal abortions or medical termination, or if there is any sex determination after conception or before delivery. So all those things are already under track and already there is a enactment is in place. However, we are going to discuss the same in a separate episode. Now let us understand the important judgments with respect to the motherhood that is been recognized in India. In 2015, Supreme Court has given a judgment where the single woman can claim the sole guardianship of her biological child without consent of her husband. That means she can raise her child as a single guardian. She need not have the name of her husband attached to the child. That means the very precondition is that child should belong to both husband and wife. But going forward, if suppose they get divorced or she wants to take the single guardianship, she can do so without the husband consent with respect to the respective legal procedure. Now let us come in 2007, where there was another landmark judgment which was given by Madras High Court, and wherein the important judgment was given in relation to the woman who has delivered a child through IVF procedure, and she wanted to keep the father's name very secret. As we all know that in IVF procedure there is a sperm donor whose name is kept in confidential. However, in law there was compulsory mentioning of father's name, which was creating a clash with the medical records. So this petition was filed in Madras High Court, and she was given a favorable decision by the Madurai bench of Madras High Court that name of the child's father need not be disclosed in the birth certificate. This was very landmark judgment, and it is helping especially a single woman or the single mothers who are not married but they are being mother through IVF procedures and all. Lastly, before we conclude, I want to discuss about Sushmita Sen's case. We all know she is an unmarried lady, and she has adopted two children, that is two daughters. However, as per Hindu adoption law, there was limitation on taking unmarried woman taking the adoption of same sex. That is, if there is an unmarried woman, she cannot adopt a daughter. She has to adopt a son. However, she has filed petition in Supreme Court, and in 2000 she was allowed the petition, and she has adopted 4 months old daughter. And after 10 years, around in 2009, she has adopted a second child under Juvenile Justice Act, for which she has filed a petition in Bombay High Court. And she has again, the adoptive law was changed and altered to suit the welfare of the child, and she was allowed to take the second daughter, whereas as per the adoption laws, two child of same sex cannot be taken in adoption. However, this was another landmark judgment which allowed the unmarried person to take the to take the child of same sex in adoption as per the Hindu Adoption Act. So I hope you have liked today's video. This was very offbeat video as such, and there are a lot of other important enactments which protects the woman's rights with respect to pregnancy, and with respect to the delivery of child, and with respect to custody of children. But it is a very vast topic, and we are going to take up all those topics one by one in separate episodes. There are other important topics which are already covered in a separate videos, and I advise you all to watch the same and share with your friends and family. If you have liked this video, kindly subscribe, and thank you so much. Jai Hind, Jai Maharashtra.